If I may introduce the panel here, to my extreme left, Abhinav Bhushan. He is Deputy Counsel ICC International Court of Arbitration. He is an Indian qualified lawyer now in ICC, and he's been visiting India to see what ICC can do with regard to Indian disputes, because I guess that is one thing which India has already concluded, that one thing we definitely need is good institutions who can deal with our disputes. And maybe this is the reverse outsourcing which India is going to do over a period of time, where a lot of jobs have come to India for the other outsourcing thing, but maybe adjudication and jurisprudence is what we are outsourcing. Then next to Abhinav is Deepankar Sanwalka. He is partner and leader risk advisory services at PwC. He has over 20 years of experience in forensics, governance, internal audit, revenue assurance, financial risk management and sustainability. He is a member of various committees at ICC, SOCHM and CII. Obviously he will give very valuable inputs when it comes to infrastructure disputes. I think one thing which it starts with and it ends with is expert evidence, forensics, fraud investigation, because that's what most of the disputes revolve on, and Deepankar would throw some light on that. To my extreme right is Shreyas Jayasimha. He is founding partner of Arna Law Bangalore, and he's been advising several Indian and international clients on both domestic and international arbitration, and also advised on bilateral investment treaties. So he would possibly bring in a bit of Indian law angle so far as the arbitration scenario is concerned, which deal with either Indian law disputes or dealing with Indian parties or otherwise. And to my next right is Simon Dunbar. He is partner, King and Spalding, Singapore, and again he's a member of firm's International Arbitration Group. He has 9 years of practice, predominantly based in Singapore, but have done disputes across all the institutions including ICC, LCIA, HKIC, SIAC and under UNICETRAL rules. So with those short introductions, I guess we all understand now what all it takes to adjudicate an infrastructure dispute, what are the main issues involved. As Pratik I think pointed out, 4 or 5 main categories of disputes, which would start from lender or business disputes to disputes between the joint venture partners or with the public sector undertakings, disputes related to corruption, and of course the internal disputes with subcontractor and contractor. So before taking too much time, let me start with Abhinav to give a little background, because since ICC is here and are doing rounds across India, and they have been speaking about ICC and what they can do with regard to the dispute resolution scenario in India. So one, maybe if you can give us a little bit of idea on the role of ICC, and particularly why would one recommend ICC arbitration when it comes to infrastructure disputes. Is there a specific regime or experience, or how would ICC compared to other institutions look at infrastructure disputes, and why would you say that please go with an ICC rather than the other institutions?
Thank you, Vyapak. I would not necessarily do a comparative analysis between the ICC and other institutions. I think everybody is doing an excellent job. But I would definitely answer the question why, for infrastructure disputes, ICC remains, and I hope will continue to remain, a very good option. And to begin with, I'll just give you a statistic. I do not yet have the 2013 statistics, but 2012 statistics still give a fair indication of what is happening at the ICC. In 2012, ICC administered about 1,400 international commercial arbitrations. These 1,400 odd commercial arbitrations were in various sectors. It was aviation, or whether it was, I have some here. Yes, it was whether it was financing, or whether it was health, pharma, whether it was industrial services, metals, raw materials, etc. But the majority of that bar amongst the in those 1,408 disputes, 16.9%, which is one sector which is heavily arbitrated in ICC arbitration, are construction and infrastructure disputes. And since 1923, when the ICC court was actually established, the sheer experience that the ICC has in managing or administering infrastructure disputes is unparalleled to any other institution for that matter. So that remains, I think, the strongest USP of the ICC and the ICC court, that it excels in administering its infrastructure disputes. And I have some examples. There are infrastructure disputes arising out of different parts of the world where Indians are involved, whether it's a road construction dispute in Africa, or whether it's an oil and gas construction dispute, where oil and gas dispute can range from technical to oil and gas specification to a construction dispute in Sudan. There are Indian construction disputes arising out of airport constructions, out of railway construction in different cities. So, and all of these have had, with this influx of new institutions in India, things may have changed a bit, but ICC remains the industry leader when it comes to infrastructure disputes.
Sure, thanks. So, obviously, when you are entering into an agreement, you do not think of dispute to start with, but one thing obviously comes to your mind is your arbitration clause itself and which institution you choose. One, of course, we have an option of ICC and the kind of depth they have in the experience and expertise to deal with it. But coming to Simon, I think, is there anything which would change if you choose a particular seat? Whether it is an India-seated arbitration run by ICC, or whether it is a London-seated arbitration run by ICC. Does that matter? Does choosing a seat is that important when it comes to any dispute, and particularly infrastructure dispute? And how would you recommend people to think about it while they were, drafting an arbitration clause?
Certainly at the drafting stage, the short answer is yes, the seat does matter. I think before we talk about seat, we just need to be specific about what we mean. Seat is, and when we talk about seat and place of arbitration, we're talking about the legal concept. Where is this dispute legally situated? We're not talking about where's a nice place to have a hearing, or Paris would be nice. Let's choose that. What we're talking about is which jurisdiction do we want policing my dispute. That's something you typically choose in advance. It's something you should choose in advance. If you don't, and you pick ICC arbitration, then the court will do that for you. The other thing to bear in mind, of course, is if you're not choosing ICC arbitration, you're choosing another institution. You're not forced to have, say you pick Singapore International Arbitration Centre, you're not forced to have seats in Singapore. You can pick and choose. But there are, I think, three major consequences of where you have your seat. It determines the law governing the arbitration, typically your procedural law governing that arbitration. As I mentioned, importantly, it determines which courts are going to either support that arbitration or interfere with it, depending on where you are. And it'll determine the nationality of your award for then enforcement purposes elsewhere. And so addressing the question, where is a good seat? Really, you want somewhere where you're going to get a fair and effective arbitration and it's going to lead to an enforceable award. You want to look for a New York Convention state. That's not hard, given there's now 149 of them, and in Asia I think it's only Bhutan, North Korea, and Papua New Guinea and Taiwan that are not parties. Obviously in the Indian context you need to be aware of the gazetting issues and the issues that China and Hong Kong faced, until recently. You want somewhere probably that's neutral, where neither party is based, or at least you ideally want somewhere where the opponent is not based. You want somewhere that has a modern arbitration law, such as the uncitral, something based on the uncitral model law or similar. And most importantly, you want a sort of strong, independent, efficient court process, because there's some talk about delocalized arbitration, but you can't really have an arbitration that's divorced from the courts entirely. You need interim relief. There's someone's going to apply for set aside, that kind of thing. So I think the courts are the primary.
Yeah, sure. Also, I think what we have seen in recent judgments is that seat would also determine the law governing the arbitration itself, because more and more judgments are connecting factors in determining what would be the law governing arbitration agreement, apart from the law governing the dispute or the law governing the substantial agreement, is connected to seat, and possibly that's why seat that much becomes more important, because ultimately if there are issues of, let's say, arbitrability or issues of interpreting the arbitration agreement itself, then possibly one of the factor which would determine as to which law should apply would be the seat law, rather than law which governs the dispute itself. So is that something which affects your decision on deciding which seat to take, or that is not something which is that important to start with?
I mean, I think what you're principally looking at is, one, I think a good way to put it is, if you wouldn't be willing to litigate in the courts of a particular country, maybe don't pick that as your seat, because it's hard to get to an arbitral process without hitting the courts at some point, or needing the support of the courts at some point. So I think that's probably a good way to approach it.
Sure.
And just beware of confusion in clauses. I mean, so many times you see seat Singapore, but a particular arbitration act shall apply. That's just a recipe for ancillary disputes and expense and cost. And
Sure.
Everything else.
Sure. Also making it more relevant for the infrastructure dispute, and I think a lot of discussion even in the first session went around the multi-party contracts, where you have different contracts having different parties with different jurisdiction or arbitration clauses. How easy or difficult it is to join all those disputes or get them into a single proceeding, and will choosing a seat or choosing an institution have any effect? Will some of the rules, let's say particularly ICC or having a seat in London, will that affect bringing this kind of joinder actions, or it won't have any effect on that?
I mean, I think that the key thing to bear in mind is that arbitration is always going to be based on consent. So you need that, firstly the consent to arbitrate, and secondly the consent to consolidate somewhere.
Sure.
You see some arbitration acts that have court-ordered consolidation, but typically in the domestic side of the act only. So really what you need is upfront, here's our arbitration clause, and we want to bring all of these disputes under all of these contracts together. How do we do it? In an ideal world, the way you probably do it is to have a separate umbrella agreement or overarching coordinating agreement, something to that effect. I've negotiated some of those, and they tend to be kind of long, complicated documents that take a long time to negotiate. It's not going to be a situation, which is the typical situation you get as the disputes lawyer, where the transactional team are kind of all ready to go. We've got the documents signed. Oh, we need someone to look at the arbitration clause. Oh, hang on a minute. Shouldn't we put something in that can allow us to consolidate all these? If you turn around and say, well, you're going to need a document that's about 10 pages long and deals with all the permutations of, if you've got multiple arbitrations, which one goes first, which consolidates into which, how do you accede to the jurisdiction of different tribunals? The transactional guys are going to tell you that's not going to work.
Sure.
So sort of as a middle step, what you can do, the best thing is firstly to make sure you've got compatible arbitration clauses, because if if you've got ICC arbitration in one and SAC in something else and court jurisdiction in something else, consolidating those is effectively impossible.
Sure.
So those factors.
So Abhinav, coming back to you, and because this is an issue which is an area of concern for everyone here. So when it comes to this kind of multiple agreements and disputes which goes beyond one agreement, how would ICC react to such a request for arbitration? Are there any rules which support some of these issues? And what would possibly a party put in the request of arbitration which would allow such a consolidation? And apart from this, what all you would advise a party to put in your request for arbitration to avoid some of these issues, including consolidation or otherwise? I would say do's and don'ts of making a request for arbitration to ICC.
I think that's a very interesting question, because under the 2012 rules, actually the ICC amended its rules to incorporate this multi-party, multi-contract under Article 6 of its rules. So, and we often receive very complicated requests, like Mr. Mukhopadhyay indicated. There are several different contracts signed by different parties which are basically they connect to the same dispute. Now, there's often a jurisdictional objection, always a jurisdictional objection. I never signed the agreement. And the ICC court under Article 6, although it's a very prima facie review, because the ultimate decision as on jurisdiction is taken by the tribunal, but under the ICC rules, the court takes a very careful analysis of who signed which agreement, whether this business or whether these agreements are interconnected or not, or whether there is an umbrella company which there's different subsidies, etc. So the key point to take away from that is when you are, and that's what Mr. Mukhopadhyay also said, was that when you are signing these different agreements, please have a consistent arbitration clause in it. Because otherwise what would happen is that one person would say, there's one dispute here, there are 3 disputes there, now let's consolidate. Now it becomes very difficult for such an arbitration to be consolidated, because until and unless those arbitration clauses are compatible, and compatibility is a different thing altogether, it is very difficult to consolidate these arbitrations, where ultimately one award would affect the other. So make sure that it's signed by everyone consistently. Make sure that the clauses are compatible. The lawyer is drafting the arbitration clause, and I was speaking at the conference day before yesterday, is that when you're entering a wedding, nobody's thinking of the divorce. So when you're entering into a deal, nobody thinks of the dispute, and the arbitration clause is probably the last clause that anybody wants to think about. But I think it's extremely important to think about a dispute resolution clause in your contract, because you need that umbrella on a rainy day, and the institution is probably that mold and that umbrella which will cover you when it rains. And answering the last leg of your question, what should a request ideally contain? I mean, I think the other institutions are different. ICC has a different requirement. Article 4 of the rules, and you may have a copy of it, has detailed guidelines as to what should be contained in the request. Essentially, it should have a summary of the dispute. It must have a copy of the arbitration agreement or agreements, and it should definitely state which agreement you're relying on, or which agreements are you relying upon. It must have the contact details of the parties. It must have a comment on the place or the seat, number of arbitrators, the language, and applicable law. So these are the essentials that must be there in a request for arbitration.
Sure. So moving forward, I think as Indians, we are not too much worried on the final reliefs, whether we are going to win or not. I think we are more worried on urgent reliefs. And a lot has been said and done by several institutions in last couple of years to deal with the Indian mentality of seeking urgent reliefs. How would ICC react to all this? Is there something which ICC helps the parties in getting this, whether it is essential, not essential? What are your
Well, absolutely, and I think again we always call 2012 as the new ICC rules, but it's been about 2 years now, and but we still like to call it the new ICC rules. And under these rules, we had this provision of emergency arbitrators. Now, there are three ways where you can actually, in an ICC arbitration, you can opt in for a conservative or interim relief. It can be either immediately after the tribunal is appointed, or it can be under the emergency arbitrator rules, or Article 28 of the ICC rules allows you to go to any court, or any competent court, to seek an interim relief. But we've had, since 2012, ICC has had 9 emergency arbitrator applications. All out of 9, 7 went through, 2 did not get through, because there are certain specifications as to the contract must be entered into after 2012, etc. The arbitrator must render an award within a specified time limit. I think it's 15 from the day it gets the file, etc. And they have worked out very well. There's often the common debate is it's an order and it's not a debate, and the enforceability question of it. And in fact, day before yesterday, there's a very interesting judgment from the Bombay High Court and HSBC PLC, where they have actually recognized an order passed by an emergency arbitrator in a SIAC arbitration. Now, of course, the order does not have the validity of an award, and ultimately those issues which are even decided by the emergency arbitrator, when the tribunal gets formed, they get to take the ultimate decision on it. But I think it is working out. It is working out very well. The parties are fostering their faith in emergency arbitrators across institutions in the world. Since 2012, we've had 9, and and we're counting forward. And so,
And how much of them would be Indian parties?
Well, unfortunately we've not yet had an emergency arbitrator order arising out of an Indian dispute, but we're looking forward to have one from one of them very soon. So it's but to answer that question, it's an effective measure. The courts are becoming increasingly confident and increasingly aware of orders passed by the emergency arbitrator.
Sure.
So
Yeah,
I just add to
please.
that, if you look at the SIEC numbers, which I think have probably got a 2-year head start on the ICC for emergency arbitrator provisions, a large proportion of theirs have some Indian connection.
Sure.
Yes,
And
they've
that was
had
more
9
the
too.
second one.
In 4 years, they've had 9 too. In fact,
Yeah.
I just got to know that day before yesterday.
Sure.
So it's increasing.
Sure. Also, I think going forward, once obviously you have put a request for arbitration, you have decided whether you want an interim relief or not. There is what we come across and we keep hearing is terms of reference, and it's not something which is possibly common across all the institutions. So, what does that entail? What is that one should know about it? And maybe I would also request Simon thereafter to comment upon as to, as a party, what one should take care of when this stage comes in an ICC dispute.
So I think terms of reference is a very typical ICC document, which is not prevalent in other form of institutional arbitration. And I worked at the ICC for 2 years, Vyapak, and I can say this with utmost confidence. It's an extremely important document. What does this document do essentially? What are terms of reference? So as soon as the tribunal is constituted, the tribunal circulates a draft terms of reference. The draft terms of reference essentially has what is the dispute about, what are the contact details, etc. of the parties, and what are the issues of the dispute. Now, what happens sometimes is there are 100 issues that parties think are contentious. When you actually come down and think 98 get resolved before, it's just 2 issues which parties really want or want to fight about. So the terms of reference essentially crystallizes the dispute into that form. And of course, new issues can always be added in later. There is Article 23(4), which gives power to the tribunal to add issues in later. But you have it's like the mother document of the arbitration. There is procedural certainty, and of course that is immediately or before and after followed by a case management conference and a procedural order number 1, which Simon is going to talk about in length. So it is. I spoke about the mold. So basically, terms of reference is that mold where the ICC arbitration basically rests upon. It gives clarity and it crystallizes issues down.
Sure. Simon, anything which you think one should be concerned about, or one should be aware about before the terms of reference get crystallized? Because possibly what I understand is that's going to be a mother document going forward. So, is this something which, as a stage, you should be very, very careful about, or is it something which evolves over a period of time?
I think the important thing about terms of reference is it is a little bit of a sort of drawing the line in the sand phase of an arbitration, which is something unique to ICC. In that, if you want to bring claims and you want to put them in, you often advise clients make sure you get them in before the terms of reference stage, because after that you're going to be at the tribunal's discretion as to whether you can bring new claims. So it it serves a useful function, sort of flushing out the claims. I'm not sure about the issues, narrowing the issues in dispute, because quite often what you see is a standard paragraph that says the issues in dispute shall be all issues in dispute between the parties over the course of the arbitration, or something like that. But I think initially is sort of flushing out and ensuring you don't get sort of hijacked halfway through with new claims and those kind of things. It serves a useful function. The other sort of added feature, I think, of the new rules is the case management conference. I think it's really a codification of existing practice as far as I'm concerned. In almost every case I've done, certainly old new rules, you have a case management conference. I mean, the tribunal wants to get the parties together, have that discussion, have that meeting. Quite often they want to have it in person, and having to sign the terms of reference is sort of a useful excuse of doing that, I think. So I think, you know, that brings that together. It also brings out, or leads into procedural order number one. One area of caution I would flag is usually what happens is a tribunal is appointed, and if you've got experienced international arbitrators, they've done a lot of these, and they've honed their own terms of reference and their own procedural number one over the years. They've tested out new things, figured out what works, and borrowed other things. What I would say is, don't just accept them. You know, this is going to be the documents that govern your dispute going forward. It's much harder to change and try new things later if you've accepted things in the procedural order. And the normal practice, in my experience, is for tribunals to circulate those as draft, collect comments, everyone has their input, now you've had your say, now live with it. You've got that opportunity to have your say, make sure you do. You know, tribunals have sort of devised these documents to suit, you know, the standard arbitration, but ultimately you as counsel and parties know your dispute at that stage much better than the tribunal does. And so I think it's important, if you think this is never going to work, or, you know, we're never going to get documents sent by courier at the same business day as this, or, you know, whatever the issue is, no matter how big or small, flush it out at that point, raise it and get it tidied up, because that's what you're going to have to live with for the rest of the case.
Sure. So, obviously, I think now once, let's assume we have all the terms of reference. I think, Deepankar, where do you fit in? Where do you come in? Particularly for a infrastructure dispute. Is it something that you have experienced that people come at a very early stage or at a very late stage? What is your take on it? What is your guidance? What are the kind of things that you come across in terms of infrastructure disputes, and where do you see people do a good job or a bad job, which ultimately affects that claim?
Yeah, I think so. The very nature of the term expert witness requires that. I think so the biggest favor you can do to a client or to the counsel is that you yourself decide whether you are truly the expert in that area or not. Very often I find people tend to become experts on areas where they're not truly experts, and that is the biggest disservice you can do to your clients. So just a case which we actually Seku and me had done. Whilst I personally do also damage quantification as well as certain valuation type cases, but in a particular case I thought there was another person who was better suited, so I got that person in from a pure valuations corporate finance angle. So I think so one has to be very discerning in terms of where first of who should be the expert. And there you can really help a lot, because you know both the client as well as the counsel. The second part, I think so, it's around being very honest and upfront as to what is doable and what is not doable. I can tell you the clients want you to, as an expert, support their claims, which sometimes border on being ridiculous. uh, and they'll just put it there in initial say, and you have to kind of put it out there that, you know, if we try to defend something like that in our expert report, trust me, in a cross-examination will get shot down. And the worst thing that can happen to an expert is to lose their credibility in an arbitration process, because then there's just arbitrators just ignore that evidence through and through. So I think so that's the second part. The third one is, how does an expert or certain arbitrators, especially infrastructure where we find, is not only a financial or a quantum expert, but you'll have a technical expert. You can have 2, 3 experts at the same time. And how do you tag team together, work truly as one team, because each one's work feeds off to another. So I have been on a couple of arbitrations where we have had technical experts and we have had us doing certain work. And there's some research and all which we have done, which helps the technical expert, which in turn their finding helps us. So how do you kind of tag team? And that's very important in an arbitration when you have 2 or more experts. Last on this one, how you can help is, I sometimes find experts trying to get into the realm of legal issues, which I think so is again a big disaster. And I find cross-examiners love to first get an expert on this kind of a thing, whether you're opinionating on an area you're expert or a legal issue, and then they just kill you on that kind of a thing if you're on the latter. So I think so one should know the sphere of work you are having, and be very clear on, like we talked about terms of reference, your own terms of reference, what you're being asked to opinionate on has to be very crystal clear, because if not, then you have an issue on that.
Sure. Also, sometimes, at least in our experience, what has happened is, and particularly in an Indian scenario, that when an arbitration starts, I think people think it's a lawyer's job or party's job, and they don't realize that one thing is to interpret an agreement, and second thing is to prove a fact as to whether there was a defect in the construction or whether actual loss could have occurred or has occurred.
Yeah.
So what are specific, let's say, top 3 areas you think where one should make sure that they make a decision whether they really need an expert, and what are the advantages you think an expert can bring in those top 3 dispute areas where just interpreting an agreement or saying 100 crore claim may not help. So what are those top 3 things which one should bear in mind when it comes to an expert evidence?
Right. So let's take a contractual dispute in infrastructure, and let's say there's a claim by a contract for extra work done, and typically it will land up to a situation and can be in a dispute as to whether the claim is valid or not valid. So I think so. First of all, there are and I think so. When you get down to agreement interpretation, there are always reasons in that and clauses in there which allow you to file that extra works claim. On the other side, there will be an interpretation on why it cannot be filed under the same. So and that I leave to the lawyers to decide as to which way from a legal point of view go. But what I kind of try to do is provide a commercial angle to that. Really, does it make sense or not, just from my own read. But if, let's say, if there was to be filed an extra claims thing, first of all, just establishing the facts, and really hard facts on which you're going to make that claim. Very often the claims are put out on some airy-fairy kind of assumptions, right? So for example, we were on this dispute which first of all went into arbitration, then given into kind of a mediation, and it was all about, for example, I didn't get provided, and which is a big issue, right? Land. I did not get the land, so I couldn't construct the road, and hence I have this huge thing. Now, how much did that factor truly contribute to the claim? I think so it has to be established very well. I think so that's where we kind of bring in that element along with maybe a technical expert and forensically examine the evidence to say yes, and because then in a cross examination we can stand up to it and then convert that into numbers.
Sure. So obviously, one understands that it's not everything is not a party's job or a lawyer's job, and experts are equally important to bring those elements out. So, what are those different techniques, or what are those steps which you would take to explain that yes, let's say if there is a dispute, as you rightly said, because of one reason you have not been able to deliver
Right.
the project, or because of certain delays of either non-availability of certain raw materials or XYZ or whatever. So what kind of techniques you adopt? What are the steps you take which will enable the parties to come to a fair bit of conclusion? Because at the end of the day, when we say let's go and take an expert,
Yeah.
one needs to know what is that he is going to do which
Right.
we cannot do. So what are those techniques, what are those methods that you apply to come to certain fact finding reports?
So I think so. We do a lot of discussions with the people, with the client on this to really understand what they are saying, and then look at very comprehensively all the records which are available. And this is where something like a forensic technology and e-discovery, not from a discovery, legal discovery, but just to examine like volumes of information and put that out comes in. So that is various stages, sometimes early, sometimes later. Site visits, really going in and examining and seeing what it is, and you may do it along with a technical expert, and depending on who's going to do what. So I think so that's there. Um, Also working that there could be certain documentation which may not be available with the party as of date, and what else you need. So a lot of times I find the whole forecasting models which have been used are so flimsy. I said, if I'm the other side, I'll just get it thrown out on day one, right? Kind of a thing. So helping the clients then really making that documentation more robust. And that is a big challenge, trust me, because clients don't like doing that because a lot of hard work, and so kind of you help put all that. So really, I think so adding a lot of robustness to it. The thing in case of we know that there's going to be discovery, so if you're going to put out what you're going to do that. So I think some of that kind of stuff really helps the client in putting it together.
Sure. Simon, I think let's say we have an expert report from Deepankar, which you have taken it either to get the damage quantification or to get the reasons or the factual aspects involved as to why the delay or otherwise. How this would be used in an arbitration? Are there strategies that you can adopt? Because that's what we started with. I think Pratik stressed a lot on strategic side of doing an arbitration, because everything revolves around how you use your material, how you best use in the right direction. So are expert presentations done, whether what we call witness conferencing or hot tubbing, which is prevalent in arbitration, how does it affect your the process? What is the right thing for a particular kind of dispute, particularly an infrastructure dispute? Whether in terms of financial experts you adopt a different way of doing it compared to a technical expert, or it is too fact specific that there is no answer. So what is it that one needs to deal with it to make best use of the expert evidence?
I think the first thing you need to do is sort of take a step back and think, what do I need experts, and what experts do I need? I mean, I think for infrastructure disputes, the answer is invariably yes, I do need experts. Then the question is, who do I need? Once you've dealt with that, you've then got to find them and get them on board early, in my experience. Too often, parties and council leave it too late.
Yeah.
We had a a dispute where client had, it was kind of unusual because they'd done a submission agreement to arbitration. They didn't like the original clause and they kind of agreed amongst themselves. And as part of that, they'd fixed the timetable for the case. And they'd done the sort of international arbitration memorial approach, which is, I'm sure as many of you know, is the, with your sort of statement of claim, it's memorial format. You put in all your expert reports, all your witness statements, all your evidence, everything, all in one. That was going to be, I think, 6 to 8 weeks after the first procedural meeting. Then it was time to shop around for experts. The number that we went to and said we need a report within 6 weeks, and they said you're crazy. So I think, I think it's important first to think about what kind of expertise you need, get the people on board, get them understanding what their scope is, and know what their schedule is as well, and factor that into the kind of the schedule for the dispute. There's no point the lawyers thinking it's a great idea to jump in and file expert reports within 6 weeks if that's just if you're going to get an expert report that's not really of much use to you because the expert hasn't had the time and hasn't had the benefit of the documents and hasn't had a chance to do a proper site visit and all of those other things that are important. So I think the key sort of takeaway is understand your dispute, particularly if you're a claimant, understand it before you even file, know what expertise you're going to need, and think that through and involve those people and know what their schedules are. I guess timing of expert reports, you have some flexibility in the process. I mean, sometimes the memorial approach works, other times it may be better to push that off until after document discovery is done and you really understand what the claims are, and then the experts can do a better job kind of honing in on the issues. So don't sort of slavishly adopt one approach or the kind of traditional court litigation approach. Figure out what works and adapt. Other features, the goal from the tribunal's perspective is to narrow these differing expert opinions as much as possible into the issues that really matter, so they can spend as little time as possible deciding things that they don't necessarily know as much about as other things. So they encourage meetings of the expert, joint reports of experts, those kind of things. I've found them of varying usefulness. I mean, quite often the experts meet, have a nice discussion, come out, and nothing's really moved. And some of it's a going through the motion sort of exercise. But I mean, that is the goal, is to kind of narrow the issues. Expert presentations you mentioned, those I find very effective. Instead of direct examination, giving experts 20 minutes, 30 minutes to do a PowerPoint presentation that summarizes their expert report. I mean, the tribunal's got it, they've hopefully read it. Whether they've absorbed it is a different question, but give them 20 minutes of someone talking to them with pictures and diagrams, and it makes it a lot more interesting. Equally, if the dispute warrants it, you can do 3D modeling and those kind of things to really get the tribunal inside the issues in the dispute. Similarly, site visits, it's very useful in many cases for the tribunal to have visited the site and just have that mental picture and that framework when they're deciding the issues. Getting 3 international arbitrators together for a week for a hearing is tough enough. Getting them to go to a remote location for a site visit is tougher still. But if the parties, especially if both parties are on board with it, I think you can try and encourage that. Then the other issue was witness conferencing, hot tubbing. Everybody likes to discuss it. Everybody's in favor of it. I'm not sure I've had the same person explain what it means the same way. So, I mean, the main thing, the concept is simple in that you cross-examine or you examine both experts together so they can sort of keep each other honest from an industry perspective. It's easy to kind of exaggerate in front of lawyers or a tribunal if you've got one of your peers next to you questioning that. It's harder. So the usefulness is there. I think, I've had cases where everyone says, okay, we'll have witness conferencing, and the 2 witnesses sit up there, and you get something that's basically like straightforward cross-examination with the other guy just sat there kind of, when's it my turn? So I think if you're going to have it, understand what that means and have that discussion with the tribunal early. So I mean, the flip side is you can prepare, for 2 weeks before the hearing, your fantastic cross-examination of this expert, and you realise what the tribunal has in mind is counsel sit down and I'm going to ask the questions and these are the questions I want answered, and you don't even really get your shot.
Yeah.
So I think the key thing is understand what you mean by it, make sure everyone means this, has the same understanding, and then adapt accordingly.
Yeah. So just to add to that, even presentations or reports, one thing important for experts is to give reports in simple English. And trust me, it's more difficult to write that rather than writing a technical report. It's just the same thing. Like I'm an accountant. I find it difficult to understand legalese. Similarly, I bet lawyers will find it difficult to understand debits and credits. So rather than writing a report in forms of accounting language, write it in simple English, because very often I find the report which is more simply understood gets more attention from the arbitrators just because they understand it better. And very often I found it works fantastically well. And presentations, again, the same thing, is simple pictures, very simple bullets, and then talk through rather than cramming your slides. No one likes that. Just some practical things on that.
And I think that's where counsel has an important role to play, because at the end of the day, we've hopefully got a similar background to the tribunal. So if we can understand it, there's at least a hope the tribunal will understand it. So I think that's a filtering mechanism.
So maybe Shreyas, you have been listening us for a long time, and obviously knowing about ICC and international arbitrations, expert evidence. But what about the ground realities when it comes to, let's say, even an ICC arbitration seated in India, or a pure domestic arbitration dealing with delays in construction or Indian economic scenarios, and experts being put before the arbitrator? What is your experience? How does this go with the Indian scenario?
Thanks for the opportunity. Very quickly, I think there is the constant need to remember that arbitration is a party-owned and driven process. Parties and counsel can never give up the duty to be creative and honing procedures and techniques that are appropriate to their case. And there is no one size fits all. There is no one protocol that they should be following blindly, even if they've done the same dispute before earlier. That's absolutely no justification to follow the same path in the next case. Having said that, in the first, I think one point we've not talked about so far is what Siku mentioned, the importance of the tribunal itself. And many times in infrastructure disputes, it makes a whole lot of sense to have a technical member on the panel. Now, and that leads to what Simon was saying, is if you do have a technical member on panel, then the type of expert, whether you need an expert at all as a witness, and the type of expert that you have to bring on board, all vary as a corollary to that first question. So I think, like any lawyer would say, your audience matters first. And so you need to understand the tribunal you're before for that dispute, in addition to the technicalities of your case, and really determine whether an expert is required. Before giving the mic up, I just want to also draw quick attention to the ICC handbook on techniques and controlling time and costs. It's in the second edition already, and there are a series of very handy tips that are very useful on the use of experts as well, and the use of witness statements. And so there are several such techniques that parties can adopt even in domestic arbitrations.
Sure.
But if I may just very quickly elaborate on Shreyas's point. Shreyas is his point.
Shreyas.
Shreyas. It's extremely important. What I think Mr. Mukhopadhyay also mentioned is drafting your arbitration clause. Now, if it's a infrastructure dispute, to be specific in your arbitration clause is always good. To be cogent is always good. But over specificity is always very bad. The institution is always going to appoint an arbitrator for you, which will cater to that, who's specialized and caters to that particular form of dispute. but you get to see some erratic clauses sometimes. I'll give you just two very quick examples. Like the many we see every day. He should be an arbitrator who has experience for 15 years in China in aviation disputes. Everybody else in China of Chinese nationality was conflicted. Some had 14 years, some did not have aviation experience. We found a woman who was excellent, but the clause said he. Then the point. Don't make the clauses gender specific. There's another clause which said we want a retired judge from South Africa who should also be a QC and had been a QC for at least 20 years. Now, a retired judge is unlikely to be a QC for 20 years in. So that's kind of a pathological clause. You know, you cannot have somebody like that. There's probably one person in the world available and who's conflicted. So drafting an arbitration clause, and I spoke at great length, and Shreyas was there at the GNLU conference, is extremely important, and therefore, again, the lawyers and the clients need to be aware that if it's a construction dispute, yes, like Shreyas mentioned, having, appointing, nominating somebody who has a technical expertise will greatly assist you. And that's where one place where ICC court takes great pride in, that they understand the disputes and the category of disputes and who's expert in which area of law. And in 16.9% of the cases, which is more than 400 arbitration cases, we always end up appointing somebody who's done enough construction disputes, who's seen enough experts, quantum, liability, how much, the numbers. So the long and short of it is draft the arbitration clause very carefully.
Sure. So, Shreyas, again, I think more particularly, again, the point we want to draw out here in this conference is, from an Indian perspective, how have you seen experts being used or not used? And how has that affected, particularly in an infrastructure dispute?
Sure. I think it's absolutely right that parties are completely underprepared for disputes in general. It's not limited to the infrastructure space. The challenge with infrastructure is that you have the contracts team, the execution team who are busy with a very heavy schedule of delivery, and then they often get burdened with the layer of supporting a dispute. I think the more mature players recognize that there is a separate team that is required to be built internally to, one, ensure that the documents are adequately maintained. The preparation and the contract management happens from day one, not from a few months before an ugly dispute is about to rear its head. And the challenge we find as external lawyers is often when we are seeking, even let's say drafting a basic notice of arbitration or the first salvo to be fired, the underlying documents and everything that you would ideally like to see are simply not there. And shockingly, even very large organizations find it a huge challenge to scurry around at that. So I can't stress, we've talked about strategy, what Prateek said. I would add another word which is equally or more important, which is preparation. You cannot get to your strategy without having your basic preparation for your disputes in order. And the complexity, infrastructure disputes are almost by definition complex. They're complex certainly in fact, because there are a series of contracts that one might have to analyze, and rights and obligations may vary, contingent obligations may arise, and it is difficult to track the precise trajectory of responsibilities through the contract. They are also complex, perhaps in some cases, because of the technicalities in terms of whether expert evidence is involved. In my experience, the legal questions that arise out of infrastructure disputes may not necessarily be complex. They may be the legal issues involved may be of quantification of the issue of damages, whether damages should be given, but the complexity arises in the quantification of those issues. So the fact-specific nature of this demands preparation on all sides, preparation on behalf of the clients, the external counsel, and of involving experts at a sufficiently early time. Of course, this hardly ever happens in India, and so this ought to happen. Each of us are actors playing one of these roles, and can therefore take ownership over being more responsible in introducing such best practices, even in our current cases, not wait for the next.
Sure. Also, Shreyas, I think most of the infrastructure development in India is on PPP basis,
Yes.
and that throws up very different challenges. If it is a private dispute between two conglomerates or two companies or contractors, I think things are very different because people think differently, act differently, react differently. But when it comes to PPP projects, a very different angle comes into the picture. So, are there any different strategies or preparations which may be required when you are dealing with a dispute which involves a PPP project and one of the parties may be a government body, or it doesn't make a difference?
No, I think it does make a difference, and I think I will internationalize the question a bit. So, take for instance, Indian business, as Shiku mentioned, investing outside. Very often, those investments are also PPP model projects. Take it in the mining space, in the infrastructure space, in roads outside. And I think infrastructure, by definition, involves long-term investments, significant investments in terms of quantum, and therefore it is highly likely that there will be a state interest that is involved, and these may be municipal level bodies which might want to exercise the regulatory control, and it may also be reflected, as you said, in the ownership model of the SPV, or that is to execute the project itself. I think it adds a layer of complexity to the issue, because two private parties, as you rightly said, can be cajoled into a sense of rationality arising out of commercial exigencies. But when state interests are involved, the decision-making structures are very different. They have, and therefore there isn't a simple hierarchical approach to escalation of disputes. And unfortunately, a cynic would say that they're more likely to end up in dispute because of the lack of mechanisms that are in place to provide for effective communication. So if it is a purely private project, it is very likely that, let's say, between the subcontractor and the contractor level, to take Shiku's example, as opposed to the owner being a PPP and the contractor, it's very likely that in the subcontractor and contractor model, you can have an early resolution of matters, because as and when they arise, they're brought to the notice, and a rational obligation, a rational solution is found in a weekly or a bi-monthly project meeting. That is not often possible when it comes to PPP models, when there are more rigid structures, and it is very difficult to explain the need for such flexible communication mechanisms at the stage of negotiation of the contract itself, because otherwise, once it is absent in the contract, it is very difficult to then introduce even a very sensible model, merely because, and it will be met with stiff resistance. So I would say in PPP agreements, one must be additionally cautious, and I personally have a set of clients who executed projects in Middle East, in Africa, and India, and they have taken a decision not to do PPP engagements in India. They have not taken such decisions in the countries that they're investing outside. So I think the takeaway is that dealing with PPP, at least particularly in India, one must be additionally paying attention to preparation and the role of experts that
Sure.
bring in.
And Deepankar, do you think there is a difference in the approach when it comes to a private dispute versus a PPP project?
Yeah.
And maybe your role.
So typically, I think so when it is an arbitration or is already a dispute, then as an expert perhaps not so much. But when it is in a mediation type of situation, and a lot of them actually, because private parties also understand beyond a point, like taking on the government, how fruitful it would be, beyond a point. So a lot of it is around, okay, it will go into dispute or is already in dispute, but let's on the parallel track continue our negotiations. So I think so it is in that sphere the mindset kind of as an expert who's supporting, helping build the case to help in the negotiation process changes. To say that okay, and provide the advice as to what is doable and what is not doable. So just we actually helped a large Indian conglomerate which had huge investments in an African country, and the amounts of disputes actually was a tune of like $2 billion, right? So now there is this international arbitration which is going on, but at the same time you have the mediation process on, and then you're trying to build various scenarios from a negotiation process. And what I think so we as a financial expert can bring to the table is very clearly setting out the implications of each option which you may choose, and if you go down this path, because that allows because as experts I think so our job is not to sit in negotiations per se, but to at the back room provide very clear cut options analysis, saying that okay, if you go down this path, then this is really what you're staring at. uh, and I think so that's clearly where it would be from in a PPV situation from our point of view.
Sure. Also, I think Siku spoke about a Supreme Court judgment which really didn't go up to the stage of who can be appointed as arbitrator, particularly when it's a public body involved, Raja Transport. But and it went up to a stage but didn't follow through in that sense. So is that something ICC can help in terms of how would they look at it differently if they are in the picture rather than an ad hoc arbitration or an arbitration done by
Yes.
somebody in the organization?
Yeah, I mean, this comes back to the quintessential, the much debated, the over discussed topic of ad hoc versus institutional arbitration. Which one is better and which one is not? But all the points that each of the panelists have spoken about, the institutional rules, the procedural order, the award, the when to do what, the procedural certainty, all of this would lack in an ad hoc arbitration. Now, case in point here, in this court, this was an ad hoc arbitration where Justice Mudgal decided that and appointed an arbitrator. Now, in such a case where either the arbitrator resigns or is challenged or is removed or dies during the proceedings, and you're left with 2 as opposed to 3, or decides, okay, I'm going to terminate the mandate of the trial. This can never happen in an institutional arbitration. Now, were that to be an ICC arbitration, or for that matter any other institutional arbitration, what would have the court done? You, of course, cannot force an arbitrator to work. He or she can resign. The court is immediately going to replace the arbitrator. It may follow the original procedure with what was in the arbitration clause, or it may decide to appoint directly. It will also take into account, now in this case, in the Delhi High Court case, I think claimant was not participating because it was being recalcitrant or whatever it was, and the tribunal said that it's not participating. The tribunal's mandate is now terminated. Now the court, an ICC definitely will go into the merits as to what was the reason behind which the arbitrator resigned, and that will directly impact the fees the arbitrator is going to get. So it is not easy in an institutional arbitration for the arbitrator to act sloppily. They always know that the institution is going to fix the fees. Now, we all know how the fees in ad hoc arbitrations are. Mr. Mukhopadhyay sitting here. Everybody knows how that's decided. There is no control, there is no check, there is no... I mean, the case in hand, you act in a lot of ad hoc arbitrations. Exactly. Probably there is no answer how it's decided, but there is an answer in institutional arbitration. You know exactly how much the arbitrator is going to get in the end. And were that to be, if the award is late, if there is a challenge, sometimes what happens is, the question of partial award, I think, is a bifurcated proceeding. In a very big arbitration, we realized after the partial award was rendered, the respondent's arbitrator disclosed that he at one point in time he acted for claimant. Imagine. And he failed to disclose this when he was asked to give his declaration of independence, impartiality, acceptance, and availability. It's a very important ICC conflict check document that we send to co-arbitrators and arbitrators before they accept to be an arbitrator. He forgot to say it. Now, there's no way for anybody to find out what's the real conflict, but he said it. And imagine what happened 2 years into the proceedings, with the partial award in favor of claimant. It was actually an Indian party. It is still, the case is still going on, so I can't reveal much about it. That award, that partial award, now is in jeopardy, because that award was rendered by that guy who was actually conflicted. And the respondent, who's who's from the Emirates, said, "This is the wrong award." Of course, he was always the claimant's arbitrator. He was biased in favor of claimant. That's why the award is against us, and it's now being challenged on grounds of public policy. So, now what did the institution do when that award came? The institution said, "My God, this should have not been happened." So that directly affected the arbitrator's fees. And now what is going to happen? The English law is applicable, and now that award is being fought in the London in the courts. So yes, all these things can be very well monitored, administered, and thought upon when there's an institutional arbitration involved.
Sure. Also, I think one small topic which we wanted to touch upon, and I think Shreyas talked about preparations, particularly on the document side, where you have to keep things in control on your side, what is there, what is not there. But when it comes to arbitrations, and there are stages where you think a document production request is required, where you think there are documents which other side may have, which may be in your favor or otherwise. How do you deal with those situations? Are there ways or stages at which you make sure you decide what are those documents, whether you can make a request to come before the arbitrator? What if those requests are not adhered to, and how to deal with this situation?
I mean, I guess typically in your sort of typical international arbitration, to the extent there's such a thing, the tribunal will set out the procedural timetable. The usual approach, in my experience, is you have a round of submissions from each side, and then a period is set aside for document production. Then you'll probably have another round of exchange of written submissions, and then hearing. There can be variations on that. And what the usual approach is to adopt the IBA rules of evidence, which specify a regime for document production requests. So what you see is parties are able to make requests of each other for documents that are in the or believed to be in the possession of the other party, and these rules were set up as sort of a civil law, common law hybrid to allow for some discovery but not full-blown discovery or document disclosure. And so your requests should be narrowly tailored. They should be requests for either specific documents or specific categories of documents that or reasonably believed to exist. And then the sort of practice is developed of red fern schedules. So you set out one column, these are the documents I want, these are why I think they're relevant to the case and material to its outcome. The other side objects, no, it's unreasonably burdensome, it's whatever. You may have a right of reply, next column, then the tribunal looks at all these and decides. What you tend to find is, unless you've maybe got a very US constituted panel, is tribunals don't have a lot of appetite for document production. The goal in this is to kind of get in, get the documents you need, and get out fast. Because the more document discovery issues drag on, you really lose the tribunal's attention span fast. So, focus, by all means have 20, 30 requests or whatever, but really focus on the important sets of documents. Keep it narrowly tailored and keep it well justified, because tribunals, I don't think at that stage of the process as well, and necessarily don't always grasp which are the key documents. They've got a reasonable idea, but there may be arguments you're still running that haven't been developed, and so you don't always get what you want or what you thought you should have got. And I think if you feel that the other side aren't being compliant with the tribunal's order, you've got a few options. I mean, if you're in a jurisdiction that allows subpoena of documents and the documents and the relevant people are in that jurisdiction, that is one avenue. It's a rarely used avenue in my experience. More important, also, the way it's usually done is you get a set of documents and it's obvious this is missing or that attachment's missing or that. You compile a list of that, go back to the other side, and probably do it offline first, and then bring out the really important stuff, and then put that in front of the tribunal. And they may rule against you, but the key then is to bring it out in cross-examination and show that they weren't complying with the tribunal's order. And the moment you do that, the credibility of the other side is impacted. So often it's a kind of bide your time approach and sort of tease it out. And you don't have the same kind of sanctions that a US court has for non-compliance with document discovery. But if through the hearing you can show that the other side weren't being upfront about the process and weren't complying with the tribunal's order, the tribunal will take note of that.
Sure. Moving on, I think, to a little different topic, and I guess Siku covered it quite well, but maybe Shreyas, your thoughts on, because every time it comes to infrastructure disputes, it's, as we discussed, there is always a government policy or a government role involved, leading to, let's say, a bilateral investment obligation with regard to investment. So what are the points that one needs to consider, whether you fall under any of those treaty protection, or at the time when you are investing, whether you want to do something where you will fall under those treaty protection, and if those cases or those situation arises, how do you deal with it?
So very quickly, BITs aren't the only way to secure your investment disputes. Previous reference had been made to ICSID. Apart from these two regimes, there are a series of trade agreements that India has negotiated with the dispute chapters that are covered. So the amount of homework that we all have to do to find out whether your investment is protected is actually quite extensive. It's not merely looking at UNCTAD or the MEA site and seeing whether there's a direct bilateral investment between the investor and the host country. Secondly, one has to examine the definitions of investor itself and of investment under the potentially applicable treaties. For instance, the Netherlands-India BIT covers both indirect and direct investments. Therefore, it's a very popular vehicle. And if you see, even for the structuring of investments into India, you'd find there's a Netherlands BV entity, and quite often it is to protect the investment per se rather than mere tax efficiency. In fact, it was been said anecdotally that if lawyers fail to advise on investment protection and were to be merely talking about tax efficiency, that might actually be negligent. And there are certain jurisdictions that view that extremely strongly. So, taking cue from that, this duty is now cast on Indian lawyers, both in-house and external, in advising Indian conglomerates in their outbound investments as well. And the last thing I will add is that these treaties have a expiry date. Merely because one has been negotiated, it doesn't mean it continues to exist. And many of them have sunset provisions where they continue to exist for about 10 or 15 years after the date on which they have expired. Many of India's notified treaties have expired, and especially amongst territories where India seeks to invest outside. So I think the government is looking at this issue. We heard 2 days ago that the government has sought a policy of renegotiating its treaties. But then when we asked who has India renegotiated treaties with, we were given the names of Romania and a couple of other Eastern European countries. And we finally figured that that need to renegotiate was not driven by Indian interests at all. In fact, it was driven by those countries joining the EU and the requirement that they had to renegotiate their bilateral treaties to be EU compliant. So the topic of investment treaties is a very important one. It is very important, particularly for investment disputes, because it's pressing the nuclear button. And companies don't want to do this. You want to invest and be in the business of business, not in the business of disputes, especially with a country you want to invest in. But it's an extremely critical strategic leverage tool, in addition to political risk insurance, and one that the infrastructure space absolutely cannot ignore.
Sure. And anything again from an outbound investment perspective, are there, because at the end of the day I think the audience here would be more uh, keen to know if they have done projects outside India or they have done things which would affect their investments or their projects outside India. Uh, how do they approach when there are no uh, you know remedies available otherwise from an investment treaty perspective? Are they very effective remedies, or are they not something they should explore to
No,
start
they're
with?
extremely effective remedies, and which is why they are spoken of with so much vehemence. Of course, ICSID, as you know, has an automatic enforcement mechanism. India is not party to it, but it's good to be aware of it. It means that the next time the World Bank gives a loan to a particular country, the amount that is awarded to the investor is subtracted from that amount directly, and then the rest is paid, the remainder is only paid to the country. India doesn't have that benefit. India Inc. does not have that benefit when it comes to investing outside. What you're then left with is the treaty regime that has been negotiated for Indian companies by the government of India, and the attendant benefits of being party to the New York Convention. Of course, as was rightly pointed out in the previous discussion, if you take your award against a host state and to the host state's courts and then say, I wanted it to be enforced, it's very likely that they'll say national interest or public policy comes in the way. Which is why in the case of investment treaties, it is third-party state enforcement that is looked at first. The level of preparation that goes on in investment treaty disputes is extreme, and therefore, even prior to launching the dispute, a responsible investor would even examine what are the potential avenues for the enforcement of this award. What are those assets that are held by the source state? They will be diplomatic. Are they covered by diplomatic immunity? Are they commercial assets that fall outside the Convention on Diplomatic Immunity? And there are ILA draft articles. And this is a topic that straddles both private and public international law, and one must consult those articles on state attribution and state responsibility to even identify those assets. And India Inc. has to learn that to take advice not only on domestic law, both Indian and the foreign law, but also on private international and public international law when it comes to remedies that it may have in investment treaty disputes. And it means that in structuring the outbound investment as well, they need to locate the investing vehicle in a treaty protected territory. Otherwise, you will find the experience of GMR now wringing its hands before the Singapore courts in a contractual disputes, unable to exercise the leverage otherwise, and India also having to rely upon old-fashioned diplomatic immunity, like for instance what Italy did with the Italian Marines case. It's not a commercial issue, but I'm just drawing the parallel to say that in the absence of treaties, one has to rely upon those ancient techniques of diplomatic pressure, whereas with a treaty-protected investment, the investor can take the initiative to proceed against the host state in
Sure.
third-party countries.
Sure. Again, I think moving on to the last topic before we throw the panel to the questions or otherwise, I think the importance, I think Deepankar put it well on mediation and the other alternate dispute resolution methods. Maybe each one of you, in your experience, how does ADR methods, and maybe we can start with Abhinav, as to in an infrastructure disputes which are obviously complex, which involves multi-party agreements, which have disputes related to technical nature, which relates to financial in nature. What is your take on the other methods other than arbitration, and how do ICC fare on that?
I think, again, so this rule book says until a few months ago it just read arbitration rules, but now they read as arbitration and mediation rules. Now, ICC has a mediation department which is fully functional and very effective, and then it again boils down to your arbitration clause. You often see a multi-tiered arbitration clause where parties first seek mediation within certain days. There's a time limit if that fails, and that comes into arbitration. And mediation at the ICC has been again one of the oldest institutions which has been practicing and trying to sort of make mediation rules aware to the world. ICC also hosts the world's largest mediation competition, which actually got over a month ago, where 500 teams were there from all over the world to participate in the mediation competition. And mediation plays an extremely effective role. Prior to the arbitration, we see some of the construction disputes actually get settled prior to arbitration starting. Now, the question of whether mediation is, the outcome of the mediation, there's a settlement agreement, there's a confidentiality, all that is there. But mediation remains a very effective tool to put in your construction dispute in a multi-tiered arbitration clause that the parties would seek mediation prior to arbitration, and ICC has elaborate rules on how to go about it. And I think there must be, at least I would recommend everyone in this room to have a look at them.
Sure. Also, that takes to a next question in multi-tiered clauses, and particularly mediation and then arbitration. Maybe Simon, are these clauses mandatory? And if mandatory, how seriously they have been taken by the parties when it comes to effectively saying that first we'll go through mediation and then arbitration?
I guess addressing the question of mandatory first. I think it really depends on seat, because it's ultimately going to be a jurisdictional issue. Or where it's most likely to manifest itself will be as a jurisdictional issue. If parties have a multi-tier clause that says, notice, then management level speak, then it goes up to senior management level, then it goes to mediation, then something else, and then you start your arbitration. Courts in different jurisdictions take different views on how strictly they're going to require compliance with that. It's one interesting feature in Singapore. There's been a recent Lufthansa decision where the courts have started tightening the approach that they're taking, and actually finding there's no jurisdiction because although there were management level meetings, they weren't complied with in the way prescribed by the clause. So the first thing I would say is fine if you decide that this is the format you want to take, but make sure you comply with it. And if you don't comply with it, make sure you get a waiver from the other side, or you go to the tribunal to stay so that those mechanisms can be complied with. Because what you don't want to do is waste 2-3 years and have an award that's then set aside. Hopefully less. The other thing I would say is think seriously about whether you want the multi-tiered approach and whether it works for you. Sometimes it's a fairly straightforward case. He owes me money. I want to start the arbitration. I don't want to talk through the 3 different layers of the company, go for 45 days of mediation and everything else. In some environments it works, in others it doesn't, but think about whether it works, and remember you've always got the option to, you can start your arbitration and then say, why don't we push this to mediation. And I know the ICC have a mechanism in their mediation rules that allows you to unilaterally file a sort of request for mediation to the ICC that will then pass it on to the other side, and it sort of adds a layer of formality to the process if you don't want to kind of bring up the other guy and say, let's mediate. So that, there's different ways of doing it. Don't always think that the multi-tier clause works, because quite often it's a period of treading water while you're losing ground strategically, waiting for the dispute to really start. And if parties want to talk, they can always talk.
Sure. Shreyas, your experience on multi-tiered clause?
In addition to my interest in arbitration, I'm a mediation evangelist, and I have a slightly parochial view, which I must confess to, which is, I think, within domestically, I'm speaking, that Delhi and Bombay have a very macho culture towards disputing. Whereas commercially minded other cities, which are not centers of power and money as these 2 cities are, for instance, Ahmedabad and Bangalore, have a extremely healthy mediation culture. And I think it is no accident that these are occurring outside where political power and economic power is so focused, because I think the stakes are so high that even if any climb down is seen as strategically impossible. That's not the case in Bangalore. So I'm very proud to say that we have a mediation culture where even at the stage of appointment of arbitrators in domestic disputes, Section 11, we seek it to be referred to the mediation center first. The law does not have to be changed requiring matters to be requiring parties to first explore mediation. It is happening as a matter of culture in the disputes that parties themselves feel comfortable, lawyers feel comfortable advising their clients to seek this remedy. I think such experiences ought to be highlighted, and parties should be given the reassurance that it's okay to mediate. One need not necessarily litigate and arbitrate all the time. Secondly, I think there are some companies that have adopted a great dispute management triage system internally, which is a fantastic opportunity to identify which buckets of disputes amongst their entire bouquet are more amenable towards settlement. And I think that internal dispute analysis is very important. I think, and thirdly, I have just come away from a mediation experience in the United States which failed a few weeks ago, more than a couple. But the takeaway is that, as he said, in this treading water business, the idea of mediation is you can come up with business solutions that you cannot obtain in either litigation or arbitration. And therefore, I would say, from a business point of view, it's very, very critical. I'll end by making a legal point that while I made out the case for mediation, please note that sometimes limitation is lurking along the way. And one of the main reasons why lawyers, for instance, ask their clients to perhaps issue that notice of arbitration is surely because it's very clear that a notice of arbitration might arrest time, but it's somewhat ambiguous as to whether a notice of mediation would necessarily arrest time in litigation, and that can.
Sure. Simon, your thoughts on the experiences on mediation, whether it really helps or...
I mean, I unfortunately don't have many mediation success stories to share, but I know the ICC does, and a lot of
I can add a comment to that. I see sometimes that during arbitration there is a mediation request that is filed in, and suddenly arbitration is stopped, and the parties sit down and they start talking settlement, or they start doing that, and there is reasonable success in that. To these rules are annexed the mediation rules, and you also have the mediation guidance notes, and I couldn't agree with Shreyas more that it's an excellent avenue to explore and look into. In fact, there's an increasing interest of students in India these days, and there's more and more going into they want to explore the opportunities of mediation. One common question I hear from all of them: what is the future of mediation in India? How is it doing outside of India? I think the future of mediation in India, I personally feel that may not be the ICC's official view, and I think perhaps it is excellent. I think it is very good to get into mediation. So yes, we see
Sure.
it's very mediation friendly.
So with that positive note, I think let me throw open the floor for questions. Maybe first from the audience sitting here, and then we'll ask the people who have joined. Anything which bothers you on arbitration which you want to ask them?
See, I'll just ask. I have been working with a lot of states, otherwise also as a developer as well as an advisor.
Sure.
A part of Island Affairs and other works, I have been advisor to states. But we find that during the drafting of the agreement itself, there is a lot of ambiguity in terms of various like PPP projects. We are contesting an infra as well as the PPP. Both the topics are hot in the country, knowing that it is needed. At the same time, we also find that there are so many cases going to come in.
So many cases
going to come in due to either non-performance of the contract or non-payment of the contract.
Sure.
One, because the parties are two different nature. One is, if you look at the pharma sector or if you look at any industry sector, the people who are contesting among each other are too educated, well organized, having a setup. Whereas when you look at the infrastructure sector, the people who are going to contest or fight between themselves are one who is an institution, either a state, because most of the projects are going to come out of the state. If it is PPP,
Sure.
it is 99 or rather 100% projects are going to come out of the state, where one person always has the upper hand.
Sure.
Right. So because you are always going to look at them as, oh, it's a state.
Sure.
Should I go against the government or not? And the other party is going to be either a subcontractor, contractor, or a developer who is matured from subcontractor contractor to a developer.
stage.
Right. So even today, if you look back to all the developers, you take the top 10 of the developers and look back their histories, they would be either uneducated promoter or who have spent 10 to 15 years of their contractual experiences.
Sure.
So to teach them that okay, there is something important in arbitration or something that is very important, they'll say, boss, first business, uske baad, let me decide about
Sure.
what is going to happen. I should not think about negatives before starting the project. So
Sure.
there are so many things that comes into. At the same time, looking at the state, the kind of maturity that municipal reforms are happening, or the state reforms are happening, where PPP are forced upon them that the project has to go through the PPP process. They really don't understand the documentation process, that okay, there has to be a legal concession, or the concession agreement should pass through XYZ processes, and then it should be given to a developer before it is tendered. How do we foresee one in that situation? So either ICC or institutions like who are into arbitration are going to come out with some circulars or something where this, or some trainings to the state that okay, boss, please adopt this because by this it is going to help us, or the developer is always going to face that the problem that okay, live with it for next 10 years because till that time arbitration is not going to mature in India, but we have to live with doing business. So what do you think?
Anybody wants to?
Mm.
I have two not very positive but frank things to say. One, there are some states that have taken the view that arbitrations have resulted in anti-state awards. So apart from the suspicion of courts as expressed in ONGC, for instance, Andhra Pradesh has taken a view that it will not include arbitration clauses in its state contracts, including its PPP agreement. They're all subject to courts. So that's one possible trend. And I quite agree with what you said about the attitude. Arbitration is unlikely, that is in the PPP space in India, in my personal view, is unlikely to improve and change overnight. It is therefore prudent for all parties involved in that space, the entities plus their advisors, to only prepare better, to only strategize better, to be able to negotiate better. That's all we can do, and then be able to involve our experts, make it as difficult as possible for a legitimate claim to be denied. I think that we talked about certain topics in the previous session of corruption and other things. Those are also factors that we see rife in the infra space when it comes to allegations are abound as to in the awarding of these contracts in the first place. So I don't think many of these actors are necessarily bathed in milk. But I think all we can provide as professionals is advice as to what best practices that they can do to bolster their current position. I don't think the atmosphere is going to improve. I think very few Navratnas have now contemplated including institutional arbitration clauses, and I don't think maybe Shiku, if he has better information, but that even if the center takes a decision, I don't think it will necessarily mean that the states will implement such a decision anytime soon.
We are discussing about arbitration.
Add to Shreyas' point, I think what is to be looked for today is the PPP bill, which is lying in the cold storage, going to be tabled in the winter session. They have contemplated some very good subjects where they have put a time limit to a PPP dispute being resolved. They have put an arbitration approach in the PPP bill, but I think the industry body has to wake up and start making a noise that bill has to be passed before the other political issues are settled, because that bill is lying since now almost a year and a half, and it's never been tabled in any session. So I think the time is to table that bill and get it passed maybe.
But even the bill produces some toothless tigers.
Yeah.
So,
See, because when we discuss PPP, when we discuss infra and arbitration, especially to these two areas, obviously a lot of maturity has to come, and looking at the investments, the kind of investment that has flowed into since last 4 or 5 years, and which is going to mature maybe next year or so.
Or result into disputes.
All resulting
Or
into
put it that way,
disputes.
maturing to disputes.
Yeah, actually into rather than saying that maturing into some yields, it is maturing into disputes. So we are going to see much more. So
Sure. Maybe the experts role.
yeah, so I
and the credit, the lawyers are looking to the credit side.
credit side. No, so my experience on this whole, and kind of I've been involved in quite a few of these across various spectrum. So many times I find that these PP things go into dispute because the terms on which a developer or someone took the contract on were unfavorable to them from day one, and they somehow thought during as the contract would have gone on, they would have worked the system to make it favorable to them. And because of this huge, today, I think so the rules of the game got changed in terms of because of the media scrutiny and all, and and those decisions could not have been taken by either the regulator or by the government, and they couldn't do what perhaps they had been, thought could have happened. So I think so that's one, and then you find excuses literally to get into arbitration on both sides. So that's one sort of things, and then I think the best is to get into a mediation type process and negotiate it out. Otherwise, it just remains stuck. The second one is something like, again, because it became public, I can talk about it. What happened on the Delhi Gurgaon expressway, right? Where it got, I think so, it got put up as a great example of a success, but then the issue came around revenue sharing, and that's where it became a big issue. And that's where I think so. Then we got hired to do an absolute kind of, it was a more of an investigation rather than honestly an expert witness, but to see really what kind of flow of traffic was there at the tolls and everything else. And it's a factual report. The issue vibrated because tomorrow, if it gone into courts, we would have to defend our factual findings and so on and so forth. So I think so. That's second. The third one is, I think so, again, where you see something like the Delhi, this whole discoms issue, where I think so it's the other way around, where I know it because I looked at a few of those things, that the cost which the discoms are incurring is actually high. Right, so there's no, and then when it gets caught on the political side. So I think so both sides, but and then that gives a bad name to PPP as an expert. So I think so what we try to bring as on the table is really help prepare our client, and I've kind of worked on both sides. Trust me, whether it's a revenue share. When it's a revenue share issue, typically it's from the government side because they are being creamed off or fobbed off. But when it is some other disputes, then typically from a developer side.
On the issue of settlement, I think the NHAI has recently settled a huge series of claims,
And that's the
because they came under
you
pressure.
have the concession agreement also, in 2003 we had the model, and now at least the only one where you have the same concession agreement repeated on all the projects with some variations. Whereas that is not the case in other PPP projects. Right? Like MSW, you take any of the sectors.
Any other question?
Hi, my name is Nikita, and I have two questions. The first question is with regard to quantification of damages. I mean, how do you pass an award where the quantification of damages is with regard to something which cannot be quantified? For example, there's this particular US case in which a girl sued a beauty contest thing because she wasn't allowed to participate in it. And she actually sued for damages saying that, oh, if she would have participated, she would have won, and, something like that. So, in such a case, how do you decide that, oh, step one is this is how you calculate? I mean, there is no step-by-step process.
I don't know whether you would be able to quantify for this
I don't
particular
think so.
girl,
That's kind of a thing.
but
No, but those are those damages are more exemplary. You're claiming for exemplary damages, right? More than quantification based on what are the actual losses and everything else, right? That's where. But so I don't think so. Something like that is where at least people like us would get involved. But let me just slightly change that situation to say where a contract has been abruptly, let's say, terminated by one party or the other, then typically you have to compute loss of future profits, right? So that is absolutely, you compute loss of future profits based on, obviously, put in assumptions, you put in situations, or how would you have foreseen a contract to have matured and acted out, and hence the profits which should have generated. And then we did actually, in the cricketing world, we have done a number of cases in that space where loss of future profits have become a big issue because BCCI has this penchant of chopping and terminating contracts whenever they want to. So I think so you can do it in that situation.
So basically, it's just a guesstimate that you just.
It is no, but you know those. It's not as simple as that. Trust me, when you get cross-examined on that so-called guesstimate, so it has to be on very solid, valid economic principles, and also the contract. And you I don't think so you can run a loss of future profits claim if there has not been some history on the contract. Let's say the contract just started off and it just got terminated. I think so. Maybe then filing for wasted costs is a better option than loss of future profits, because you may not get future profits, you may end up getting wasted costs.
So on the same thing, like for example, when you have two expert witnesses and the result for a particular arbitration being absolutely opposite. I mean, one expert witness says something that, for example,
Very
the
often it
value of
happens,
what
yeah.
you're saying.
Always the case.
Yeah. So then how do you, I mean,
So-
eventually it comes to become, it
Yeah.
becomes a character assassination that, oh, you're basically not a good witness enough or something like that. And,
No,
and
I don't think, sorry, but I think so as Simon talked about, issues about witnesses talking to expert, talking to each other, witness conferencing, and and then who's able to articulate their viewpoint better during the presentation or the cross or whatever it is to the arbitrator. And that's where I think so it's important to, I always say, write your report in language which the arbitrator understands, in very simplistic way. So as a rule, I don't think so I've ever written a report, the main report, which goes beyond 35-40 pages max. I just don't like it, because I said no one has the patience to read, and if there's anything else, I keep on putting it in appendices. So no one anyways looks at the appendices. But the idea is to be able to put your point out emphatically, succinctly to the arbitrators.
And taking that one step ahead, the arbitrator has to put in a reason as to which report the
Yeah,
arbitrator
exactly.
liked better and why.
Right, exactly.
And because when one party is going to win and the other is going to lose, the losing party also presented an expert, but apparently his expert's report was not taken into consideration. Why? He wants to know. And that's the difference between a good award and a bad award. That whether the reasoning is good or bad is irrelevant. Whether there's sufficient reasoning and whether that reasoning is explainable is what a good award or a bad award is. Now you
So-
may not agree with it, but it's there.
Actually,
You can actually challenge only the quantification phase
Yeah.
and go back to the tribunal, which happens in many JV disputes. Even after the award is over, you'll get a new expert to say that, okay, there's a quantification error. You had to calculate from X day using X EBITDA multiplier, using X projection, using X 5-year plans. Based on that, the Y should be the value. And now then you get the expert to say which EBITDA multiplier to use. What are the 5 years plan to apply? Which Excel sheet should be followed? What is the actual loss building cost? And there's many situations where you actually grill the expert as to why are you saying this.
oh, it always. The other point is that, I think, taking over Abhinav's point, so we have, I've been on cases where my report has been accepted, yet the client who paid my fees actually lost the arbitration. And I'm absolutely fine with this, because fundamentally my job as an expert, I actually say, is to help the arbitrator more than anything else understand the key issues and arrive at a logical answer on the issues at hand, at least on which I'm opining.
Because you have to understand quantum and liability are two different things. So you may be able to prove your quantum, but not the liability. So
Yeah.
On your point of guesstimate, at times it's generally not in intra disputes. It doesn't remain guesstimate. It's like tomorrow, if you're building a bridge and 18 consignments of cement came less, I can actually go back to say that how many days in that the bridge would have been complete, in that how much revenue I could have earned,
Yeah.
because of that how much contractor extension I need to give, how much extra concrete I need to buy from somewhere else. And I take that and give to Deepankar. Deepankar runs it on an Excel sheet. It looks very good with all the pie charts, and you present it to the tribunal. So that's how it generally works. So it's no more a guesstimate. These guys do a decently good job to give us something more than a guesstimate.
The point I wanted to make on YAF, because of the young arbitration enthusiasts here, there are programs in helping you cross-examine not just fact witnesses, which Pratik has done, but also an expert witnesses. And these are programs that even some expert witnesses seek to attend. I'm part of another group called the Federation of International Arbitration Advocacy, which is Geneva based. and we conduct these programs. And so, do watch out for these training programs, whether you're an expert, whether you're a party, or whether you're a lawyer seeking to get into this. The kind of questions that you need to, the expertise that you need to develop to deal with experts is a trained skill.
Sure.
And sometimes those experts are in a different language.
No, actually, I always, at the end of the day, I'm an expert in my area, right? And it's honestly, if you keep your wits about you, it's difficult for a cross-examiner to get past you because you're the expert in your area. So I think the cross-examiners, and I help cross-examiners prepare for the cross-examination, and I land up actually spending a lot of time doing that because they need to ask the relevant questions of the other side, and why should they be asking the questions, and how it kind of flows out.
Any last questions or comments or anything the audience wants to share or ask? Okay, so I think with that,
And just before we end, I have to unfortunately do this since it's an ICC YAF, and although Shreyas is the regional representative for ICC YAF India chapter, and Mr. Chiku Mukhopadhyay himself, one of the vice presidents of the ICC court, is here. I would like to just thank Nishit Desai Associates to host. This is the second ICC YAF in India. We're very grateful. I would especially like to thank Simon Dunbar, who came all the way from Singapore to attend this YAF. In fact, he has a flight to catch in the next few hours, so it's going to be long. Well, thank you, Simon. I would like to thank Deepankar. I would like to also thank Shreyas. He's been whatever is due. And I would also like to, what must be done is that I called Mr. Chiku Mukhopadhyay. It's not very easy to catch Mr. Chiku Mukhopadhyay for all the right reasons that we know. And he had an arbitration. He had an arbitration got cancelled, but nonetheless he made it to the YAF. So thank you very much, and we look forward to having many more YAFs in the coming months.
thank you.
Thank you.
Thanks a lot.
Thank you.
Thank you.